Good morning everyone, and welcome to this month's webinar in which we're going to talk through holiday entitlement rules, and hopefully we'll be doing this in simple terms because as many of you probably know, when you navigate the complexities of annual leave, entitlement and pay, it can be challenging, especially when you employ workers on irregular hours or for just parts of a year. So today our aim is to provide you with clear and concise information to help you understand the rules. I do want to point out at this point that the rules we're discussing today are relevant to businesses operating in England, Wales and Scotland. So if you do have any businesses operating in Northern Ireland, then the rules that were set out by the Harper Trust case ruling continue to apply over there, and that's a very different topic in itself. So let's continue with today's session, and before we get going, as usual, we do like to introduce ourselves. So I'm Victoria Templeton. I'm the HR Knowledge Manager here at HR Solutions, and I'm joined by Sue Watson. Sue's our Operations Director, and together we're going to take you through today's topic. We've got so many of you here today, which is great, and we've had to place you all on mute, so but we do want to get your involvement as much as possible in today's webinar, and we'll do that in a couple of ways. First of all, inviting you to ask us any questions. We are going to attempt to answer holiday questions at the end and answer as many as we can, but obviously given the time we may have to do some follow-up afterwards. But do please submit your questions as we go through, and you can do that by using your GoToWebinar panel, which looks like something that you can see here on the screen. Please type the questions as you feel that you've got them as they come up. Can I just check my slides are moving?
Yes, they are.
Yeah, lovely, thank you. And we also like to make our webinars as engaging as possible, and we'll do this by using polls. So these not only help steer our webinar, but it allows us all to share how the topic's being managed in our own workplaces, and so it can really help generate ideas for other organisations on the call, and sometimes it can be reassuring to know that you're doing things similar to how other organisations are doing things. So when you see this slide, we're going to run a poll. They are confidential. We only obviously publish the results, so please, if you can, take part in those polls. So what I thought I'd do in terms of structuring the session, we're going to just cover the topic by first of all setting out the key principles that are set out in law that all employers must have regard for, regardless of types of workers at this stage. We're then going to look at the rules in terms of how they relate to holiday entitlement and pay, and how they can differ depending on a person's working arrangements. We're then going to focus specifically on managing holiday rules for those who work irregular hours or part-year workers, and that's the area that's the most complex. And then towards the end, we'll cover off sharing some useful tips, and we've got some examples to take you through as well. And then, as I said, at the end, we'll aim to answer, hopefully answer your questions on holiday calculations. So before we get going, we're going to run a few quick polls just to really understand the audience, everybody here today, and just get a feel for the organisations you work for, the type of sectors you operate in.
So there we go. I've launched the first one.
Thank you. Have a look.
I'll close that poll and share the results.
Okay, wonderful. So covering all size organisations, but predominantly small and medium. Brilliant. And then we have another poll which is about really who's responsible for human resource management in your business.
Okay, I will close that and share those results.
Okay, Brilliant. Yeah, we 9% business owners and office managers, and it's interesting, isn't it, how it gets split up within organisations. So that's interesting.
I've just loaded the one which is about the sector. And then I think we've got one more, haven't we?
Yes.
Okay, I will close and share that one.
Okay, so the big question.
Okay, and then the next one, the last one in this section.
Do you know how to calculate the entitlement for irregular hours of pay workers?
It's interesting how this keeps changing.
Yeah.
Yeah, I think we're settled now, so I will close and share that one.
Wow. Yeah, 52 and 48, and that doesn't surprise me. And for those of you that did the 52% of you, you're not on your own. And even when the rules changed last year, you had barristers, you know, high profile public professionals just talking about how complicated the rules were, how the regulations were not watertight enough, there was still ambiguity. And I know as a HR practitioner, and if there's any of you on here that work in HR, you know, it isn't the easiest of things to sort of get your head around. So the 52% of you, you're not on your own. So I think let's move on with the session then. So we're going to talk through in this section the key principles in general terms about holiday leave and pay. And I think the first thing really is to emphasize is that holiday entitlement and holiday pay are two very different areas, each within their own rules for how they're managed and in the way you calculate them. And it's a really important thing to distinguish it because, as I said, there's many different rules for each. And when we think about the amount of annual leave, then under the working time regulations, we have got 5.6 weeks paid annual leave. Now, we introduced the working time regulations on the back of the European Derived Working Time Directive. And in the UK, we all receive that basic 5.6 weeks of paid annual leave. And that's the same as saying 28 days. Because if you divide 28 days by your 5 days of a working week, that gets you back to your 5.6 weeks. The law refers to 5.6 weeks in writing. When the UK introduced the European directive, it brought in 4 weeks of basic entitlement. That was what was required, but the government at the time provided an additional 1.6 weeks to make that 5.6. That's the additional entitlement. So you've got 4 weeks basic entitlement and 1.6 weeks of additional entitlement. This is really important because there are different legal rules behind each of these two pots of annual leave, although in practice we find that employees just count all 5.6 weeks as one pot and don't differentiate, and that's purely because of the administrative burden on having to manage two different pots of leave. But it'll all become a little bit more apparent as we go through the slides. Holiday is prorated for part-time workers, and we're going to go through that in further detail in the webinar, and it is an area that really does confuse and is complex. Just to clarify, those who work irregular hours or part-time hours, irregular part-time hours or part year only, they just have one pot of holiday of 5.6 weeks. There's no distinction between the 4 weeks and the 1.6. So that's from a technical perspective, what's within the law. But as I said, it'll become a little bit more apparent as we talk through what it means in practice. There's also carryover rights in terms of unused holiday, and they can pretty much be determined by the type of employment arrangement and the reason why the holiday needs to be carried over, and the number of days it can be carried over, which again I'll come on to in this session. When dealing with holiday pay, the rules are different to how you manage it to when you manage the entitlement itself. And the rules surrounding holiday pay are determined by the nature of the contractual working relationship. So if you are full-time or you work part-time but with regular hours, you must be paid at the time of taking your annual leave. If you work irregular part-time hours or you work part of a year, the employer has the ability to either pay holiday at the time it's taken, or they can opt to use rolled up holiday pay, which I'll come on to again, as I said, later in this session. When it comes to the payment in lieu of leave, that's not permitted under the legislation. You're only allowed to legally pay somebody for untaken holiday when they leave their employment. So today's session, I am talking about the statutory provisions, the absolute minimum, but there may be some of you on here today that do offer enhanced holiday. So if you do offer more generous holiday terms, then it means you've got greater freedom to set the rules for how you manage those additional days. You still have to follow the rules for the statutory 5.6 weeks, but any additional days that you're giving, you can set rules appropriate for your business. So as I said, for the purpose of today's webinar, I am purely talking about statutory leave provisions, although I will mention in certain parts contractual entitlements, just because there's a certain few things that I need to flag for you to be aware of. And last year, the law changed in that it's, I guess, tightened up on the prevention of underpayment of annual leave. We've seen many case rulings in recent years that illustrate the key principles in how annual leave must be communicated and must be managed. So as part of the reforms last year, if an employer fails to recognise the worker's right to paid leave, or if the employer fails to provide the worker reasonable opportunity to take their leave in the leave year, or fails to encourage them to do so, or even fails to inform the worker that if they don't take their leave in the leave year, they'll lose it, it means the worker will now has the legal right to carry forward indefinitely until the employer has rectified the situation. And the case rulings we've seen is about how employees haven't been reminded of the holiday, they've lost holiday when actually they didn't have sufficiently clear holiday processes and procedural terms. So that's a big development from last year. So before we get on to the next different types of working relationships and holiday, we're going to do a quick poll. This is literally just one quick poll, and it's really understanding your holiday year. And it will become apparent in the coming slides.
Okay, I will share those results.
Quite interesting.
Mm.
Oh, so both January to December. Okay, and then something else. I'm intrigued.
But we have got clients that have like November holiday day starts, and it aligns with certain things in the business, or because of seasonal things. I mean, some of the questions that are coming through are around, you know, is it okay to spread holidays throughout the year? So, or ask people to take so many by a certain point during the year, and how many people do that? So, and sometimes people have holiday years that encourage you to take all of your leave. If you're taking a lot of leave accrued at the end of the holiday year, that it doesn't hit them at their worst time. So
yeah,
that's just an interesting observation.
okay.
Anyway, I've heard that out.
Yeah, thank you. And so I'm going to now just sort of clarify around the rules for different groups of workers. So hopefully I'll make this as clear as possible because it gets a little bit confusing. But essentially, we've got two sets of rules. You've got a set of rules that apply to the workers who work full-time, part-time with regular hours. So, you know, example here, Monday to Thursday, 10 till 2. The hours don't change, they're set. You then have another set of rules for those workers who work regular hours or part year. So, for example, somebody that's a term time worker, or if you employ somebody on a 0 hours contract, or if you engage somebody on a casual worker agreement. So it's really important to know that there are these two sets of rules for how holiday entitlement is calculated and how holiday pay is calculated as well. Because if you get it wrong, that's where it's costly, because you'll get claims through tribunals for the underpayment of holiday pay. So if we first look at the most straightforward aspect, when somebody is part-time with those regular set hours, this is more straightforward because you can calculate a length of a week of leave based on their working arrangements. And if you remember, in the legislation, it says that you get 5.6 weeks. So it talks in weeks. So you've got three examples here. Somebody working Monday, Tuesday, Wednesday, 9 till 11. They work a 3-day week. So they get 5.6 lots of those 3-day weeks. Equally, example B, Tuesday, Thursday, Friday, again is another 3-day week, albeit working more hours, at 12 hours. And then you've got example C, where they work a 2-day week. So in terms of the practical application of it, assuming the company's entitlement is, they follow the statutory minimum of 5.6 weeks or 28 days, to calculate what the worker is entitled to each year based on their working hours, you'd use the following formula, which is the number of days worked each week, so the 3 or the 2, divided by the number of working days in a week, 5, and then multiplied by 28. So as you'll see in the examples A and B, both of whom work 3 days, they would earn 16.8 days worth of annual leave in a year. So this is a straightforward way of calculating part-time holiday when they're working those regular hours. Example C, working 2-day a week, they will receive 11.2 days of entitlement. So as I said, looking at A and B, they receive the same entitlement, don't they, of 16.8 days. And even though they're working different numbers of hours, it's not relevant to the calculation because they get 5.6 weeks. So a week for person A is 3 days and a week for person B is 3 days. But on the face of it, it can look odd that, well, they work more hours, so why don't they get more holiday? But it's because it's all based in weeks. So the second group we have are those that work irregular hours and part year. And that's where it becomes complicated. And the law changed last year and provided some clarity because previously we were going by the Harper Trust ruling. And so I asked in that poll about your holiday years. And the reason being is because when these regulations were reformed last year, they took effect from for all holiday years starting on or after the 1st of April. So for those of you here that have a holiday year of April to March, these rules should already be in place in your business for how you deal with irregular hours and part-year workers. But for those of you, the majority of you, I think, wasn't it 55% of you, you've had to wait until January this year to bring in these changes because you couldn't introduce them partway through a holiday year. Hopefully I'm making sense. So the reforms from last year, everybody that's got a January to December holiday year, hopefully January, a couple of months back, you then move to the new ways of working. So just make sure that if you do have that holiday year of January to December, you are managing your workers correctly in what I'm about to sort of take you through on this webinar. Now, the reforms that came in last year, as you'll see here on the slide, we have a new legal definition of who is an irregular hours worker and who is a part-year worker. And the employee must meet that criteria to then have their holiday managed in the rules I'm talking about. There's a new method for calculating holiday entitlement. We must now also base our holiday accrual calculations in hours, not days. And we have a new method for calculating how much statutory holidays accrued following a period of statutory family leave or sick leave. We've also had the reintroduction of rolled up holiday pay. I don't know if many of you will remember, but many years ago it was a lawful method of calculating. We've now got that back in place, and we've also seen some changes to the carryover rules. So we've got 3 polls at this stage, so it'd be great to get your input and your thoughts. And the first one being, do you employ irregular hour workers and part-year workers?
Okay, just let that run a few more seconds.
Okay.
Okay, I will close and share those. So yeah,
So
significant number.
Yeah. And for those 64% of you, if you wouldn't mind just answering this next poll, it's a slightly different take from the earlier one. So given you do employ these types of workers, do you know how to calculate their entitlement?
Okay, I will close and share those.
Okay.
Pretty even.
Yeah, and hopefully
Slightly
the next few slides will help you. And obviously
we've got one more, is it? One more at this stage.
Yeah.
Yeah.
And then I guess for everybody now to answer, what's your biggest challenge when it comes to managing holiday?
A few people have commented on they have holiday pay that is aligned with each individual employee's start date. So that could cause them quite a lot of admin in terms of holiday years, because they'll have staff caught by both same time.
Yeah, so the holiday year starts from the day they join.
Yeah.
Yeah, okay.
I don't think many do that, but there are definitely some. So I'm going to close and share those results. There we go.
Let's see. So yeah, the calculations of entitlement. Yeah, knowing which rules to apply to who.
Yeah.
So we've got lots of information coming up that will help understand who falls in which category, and obviously the calculation of it. Thank you for that. So I think it's fair to say the challenge we've got when managing holiday entitlement for those who work irregular hours or part year is that when a worker has that 5.6 weeks annual leave entitlement, how do you calculate both the length of a week of leave and the amount of a week's pay? That's the biggest challenge. And the reforms that came in last year were introduced to help in dealing with that challenge. So let's see if they do help. So let's look at some of the key developments. So this is just a summary of what I said a few slides ago. We've got that new definition now. So those of you who just indicated you weren't sure on which rules applied to who, then I'll take you through that in a moment. We've got new definitions for what we mean normal remuneration. We've got updated carryover rules. We've got new methods for how you calculate holiday entitlement, both during when you're in the business and also when after a period of absence. And then, as I said, we've got the reintroduction of rolled up holiday pay. So the first area to start is really understanding the definitions, and this is defined in the legislation. So to be an irregular hours worker, they define it as being if the number of paid hours that they will work in each pay period during the term of their contract in that year is under the terms of their contract, wholly or mostly variable. Now just make a note of those words, wholly or mostly. That's going to be relying on test cases. We don't have definitions of what those two words mean. So it's going to be for an employer to make that judgment on looking at the records of the hours that have been worked to make a judgment on whether they're mostly variable or not. So that's an area for the employer to make a judgment, but essentially it's about where the hours are variable. The definition for being a part-time year worker, part-year worker, sorry. So if under the terms of their contract, they're required to work only part of that year, and there are periods within that year of at least a week which they're not required to work and for which they're not paid, that's part-year worker, and it includes part-year workers who may have fixed hours. So for example, think teaching assistants who only work during term time and who are paid only when working. So what's really important is that these definitions are purely for the purpose of calculating holiday entitlement and pay. It's got no bearing on assessing if what somebody's employment status is for the purpose of legal rights. That's a separate conversation. But so these are the definitions for when it comes to calculating holiday. We also now, in this third column, have it written into law what is meant by normal remuneration. And in fact, it probably shouldn't be too much of a change for employers, because in recent years, we've had to keep up with the outcome of several case rulings that have given us this guidance. So it's really more a matter of putting it down in writing. But what they define normal remuneration are those payments that are intrinsically linked to the performance of tasks which a worker is contractually obliged to carry out, payments relating to professional or personal status relating to the length of service, seniority or professional qualifications, and payments such as overtime that have been regularly paid to a worker in the 52 weeks preceding the calculation date. And again, we've got the word regularly. What is that? And that's going to be, again, for the employer to make that judgment on whether these payments are regular. And this is all important, this definition, because it's telling you what amounts you need to be including when you do your payroll calculations for paying holiday pay. So looking at the carryover rules, so there's a maximum of 8 days that can be carried over into the next leave year with the agreement of the employer. For those of you that provide more than the statutory 28 days, just check your own contracts around the carryover rules for that contractual element part of it. Up to 28 days statutory leave can be carried over if the person hasn't been able to take all or some of their leave because of some form of statutory family leave reason. Where statutory leave hasn't been taken due to sickness, it can be carried over, but this is where it gets complicated because it depends on the which of the two types of workers that I've just gone through. So, for example, those who work regular full year have the right to carry over up to 20 days. But if somebody is an irregular hours worker or part year, they can carry up to 28 days into the following year. I don't know why there's that difference. I can't explain it, but that's a difference in the law, and that's why it's really important to know which category your worker falls in. Now, the carryover leave must be taken by the end of the period of 18 months, starting from the end of the leave year in which it was accrued. So I'm going to now focus on the calculating of entitlement. So employers now, and this is relating to the irregular hours and part year workers, you must calculate their entitlement using the 12.07% method. And again, I would think many of you on this call will know that this is something we have been able to use in the past. It was banned and deemed unlawful, but through various case rulings and the reforms last year, it's been brought in as a lawful method. So the 12.07% method is essentially giving workers holiday entitlement that equates to 12.07% of the actual hours worked in a pay period. So when we talk about pay periods, just to clarify, so if you're paying somebody weekly, it's that, or it could be monthly, fortnightly. So it's the frequency which somebody is paid. Now the 12.07, just to put it in context where this comes from, if you remember, the statutory entitlement that everybody has is 5.6 weeks of paid leave. If you take that away from your 52 weeks in a year, that leaves you with 46.4 working weeks that are available in any holiday year. 5.6 weeks as a percentage of the available working week is your 12.07%, because if you divide 5.6 divided by your 46.4 figure times 100 to get it back to a percentage, that gives you your 12.07%. So essentially your 12.07% is the equivalent of saying 5.6 weeks. So it comes back to the right that part-time workers must get a prorated amount of holiday. That will give you a prorated amount of holiday for them where they're working, obviously the irregular hours and part year workers. You don't use this for somebody that works part-time regular hours, because in those examples I shared earlier on, that's more straightforward. You know what a week is. This is purely for when you've got somebody working irregular hours or part year. So just to flag here, I know this is pretty much around the statutory position, but I just wanted to flag that if you do offer above the statutory minimum, then you need to bear in mind that the 12.07 is actually based on 5.6 weeks. But if you're not offering 5.6 weeks, you need to find a different percentage. So in the example here, say for example you give 6 weeks annual leave in your contracts of employment, you will need to find out what your 6 weeks is as a percentage. So in here you can see that you take 6 weeks from your 52 weeks in a year. So you have in your organisation 46 available working weeks. 6 divided by the 46 gives you the 0.13, but to get it back to a percentage, times it by 100. So in this case, you would calculate an irregular hours holiday entitlement using the 1304% calculation, not the 12.07. If you didn't, and if you just stuck with the 12.07, you'll be in breach of your contract because you're not giving them their full contractual benefit of the 6 weeks. You're only giving them a percentage of 5.6. So when there's a period of family leave or sickness, you calculate how much has been accrued, again using your 12.07% method. Obviously, like I just said, if you offer contractual, find the percentage relevant to you. And the reforms that came in last year introduced a new 52-week relevant period, which allows employees to look back and to calculate average hours worked across a period. And it's about finding those average hours and then use that in your calculation to find out what holiday has accrued during maternity leave, adoption leave, sickness absence. So what you need to consider when you're counting back your 52 weeks to get your data, do not include weeks where the employee has been on maternity or family leave or sick leave for any amount of time. Weeks not worked for any other reason should be included. Where these types of absences have occurred, such as your family leave, sick leave, then it means that you need to go further back than the 52 weeks. So potentially the maximum you can go back as defined in the law is 104 weeks. So essentially what that means is your 52 weeks isn't necessarily consecutive weeks. You've got to bypass some weeks where, for example, they've been on family leave, etc. If you've got a new starter, then you just go back as far as their start date, and then you get your average hours divided by however many weeks. So just a quick poll, just to sort of check in with everybody. Is everybody calculating holiday entitlement using the 12.07 method and the accrual method? For irregular hour workers, this is.
Okay, I'll share those results now.
Okay. Okay. So 39, is it 39%? Okay.
Yeah.
So, you know, the aim of today is to help provide information and support. So hopefully what I'm going through today will help you look at what you need to do in your business moving forward. By all means, you know, get in touch with us if you need any further clarity. And I guess it's just assessing if to what extent there's any risk for your business, if anybody is lost out as a result of that. Don't know if you've got any other thoughts, Sue.
Yeah, absolutely. I think it's there are lots and lots of questions coming through about all the different scenarios. I think we are answering some of them through the slides, but clearly it's that there is a lot of concern around the intricacies when you look at the detail and you look at your variable patterns and working ways of working. It is actually quite hard to get your head around it, and you may have staff under multiple different ways of needing it to be calculated or considered. So I think this one is probably going to need a Q&A follow-up. There are some questions that we can raise later, but definitely it is causing a lot of people to think carefully about how they're operating.
Yeah, absolutely. I will do some follow-up to those questions. Thank you for that. So the slides that I've just gone through is about the entitlement, the holiday entitlement based on the 5.6 weeks and getting it prorated for somebody working irregular hours. Now we're going to focus on the pay side of it, because if you remember right at the outset, entitlement and pay are completely separate things. They've got their own set of rules. And really, you know, you need to work out the entitlement first. And once you know the entitlement, it's then working out and getting your head around what it means from a pay point of view. So if you remember, I explained there's two pots of holiday for those who work regular hours part-time and all year round. Those who work irregular hours part year just have one pot. This table is just to illustrate from a statutory position what the law tells us. So, and it depends on the employment status. So like what you can see here is for those who work the regular hours full year, for the basic entitlement, which is your 4 weeks, they get paid holiday at the normal rate. So if you remember that definition I spoke about. But for the remaining 1.6 weeks, technically from a statutory position, employers only need to pay the basic rate. When you look to the right side of this table, you've got irregular hour workers and part year workers that actually get paid the normal rate for the whole of their 5.6 weeks entitlement. There's no distinguishing between 4 weeks and 1.6. It's all paid at the normal rate. And, you know, again, I don't have answers as to why that is. But I think what's common, what we see is that it's common for employers to just pay one rate for the entire 5.6 weeks, simply because of the administrative burden on managing two types of holiday pay. But obviously it was important just to highlight that, what the statutory position is. But obviously you probably may have working practices that apply just the normal rate throughout. But that's a clear difference, which is why I just wanted to highlight that for you. So here is that reminder about what is deemed normal remuneration, as I said a few slides back. So payments intrinsically linked to performance or tasks, payments relating to professional or personal status in regards of length of service, seniority, and payments such as overtime that have been regularly paid. And again, what is regularly? That's going to be a judgment for the employer. So since last year, employers have been able to introduce rolled up holiday pay. It can only be used if the worker meets the definition of either an irregular hours worker or part year worker. It cannot be used for other part-time employees that have regular hours or full-time employees. What it does, it allows the employer to pay an additional amount of money in each of the pay periods to cover an amount to represent their holiday pay. It's an alternative way of paying holiday instead of paying it at the time the leave is taken. So basically that employee gets a constant amount of money over the year in their pay that reflects a proportionate amount of their 5.6 weeks based on the hours they will have worked in that pay period. If you are looking to introduce rolled up holiday pay, it's got to be incorporated into the contract of employment. Obviously it's going to be a contractual change, and it's obviously got to be clearly set out in the policy. It can't just be something that you do, and it's got to be an element that's shown on the pay slip. The alternative way, if you don't use rolled up holiday pay, is, as I said, pay at the time the leave is taken, which is what we're all familiar with. And when you do this, it again uses a 52-week reference period. So again, when you're having to look back. However, just to confuse things, we have two slightly different reference periods. So this one, when it comes to pay, is slightly different to the 52-week reference period that you use to calculate entitlement. And I'll come on to explain, but it essentially uses an average amount of pay from the last 52 weeks in which the worker has worked and earned pay. The reference period begins from the day before the employee starts their annual leave and goes back for those 52 weeks. And I'm going to just talk through what's included. So again, it's another thing of it's not always necessarily going to be consecutive weeks. So you must not include weeks where the employee has been on maternity, family, sick leave for any amount of time. Where these types of absences have occurred, it just may mean that your relevant period needs to go back further than 52 weeks and go up to the limit of 104 weeks. Weeks that have not been worked for other reasons should be included. And that's the bit that differs to the previous one. For new employees who have not worked 52 weeks, you go back as far as their start date. So here, this table is actually an extract from the government's guidance document called the Holiday Pay and Entitlement Reforms. And I just wanted to highlight it because it just puts into perspective some different scenarios. So what you can see here is if you've got somebody that's been with you for over a year with variable pay, you average their pay that they have earned over the 52 weeks. If they started 20 weeks ago, then you average it from the pay received over those past 20 weeks. Now in the third one, if you've got somebody that has worked regularly and over the past 104 weeks has received pay in just 45 of them, because they've only got those 45 applicable weeks in the last 104, holiday pay is calculated using an average from the pay that's received over the 45 weeks. Employees that work irregularly in the past 104 weeks but have received pay in the 75 of the weeks, then you average it out, but only the most recent 52, because as I said, it's a 52-week window you're looking at. And then employees who work part year and over the 52 weeks, they have worked 25 of them. Holiday pay is calculated using an average from their pay of the 25 weeks in which they've earned pay. So just a quick poll again, and this is around, are you calculating holiday pay for these types of workers using these rules?
Just to be clear, we're now talking about pay, not leave entitlement. They're two quite different things. I think that's what does confuse some people, because the rules are different for pay to leave entitlement, and it certainly confused me quite a lot initially when I tried to get it sort of settled in my head. But yeah, so I will close the poll and share those results.
Thank you. So sort of similar numbers to before. Yeah. Like I said, you know, now we're sort of taking you through this. Hopefully it's giving you some things, takeaways for you to think about for your organisation.
Okay, to you.
Thank you. So these last few slides, before we get to some questions and things, is really just to share some useful tips, and got a couple of examples as well. Oh, let me just put all the animations up. Apologies for that. Okay, so I think the first thing is make sure you're accurately classifying your workers. Do they fall in the irregular hours worker pot, or are they considered a regular hours part-time worker? That's going to be key, because then it defines how you manage their holiday. It's so important to understand how you process both the 52-week relevant period for calculating entitlement to leave, as well as the one that's in operation for when you're calculating pay. Make sure you're managing the variations in pay correctly. So if you remember, the normal remuneration needs to be including your bonuses and overtime. So make sure your records are capturing all of that data, and actually maintain meticulous records of hours worked, the pay slips and holiday taken, because it needs to take quite some monitoring and administration of managing holiday entitlements and holiday pay. Think about how you can consider using technology perhaps to automate pay and hours worked. I know we have a calculator available, which I think we've got some information on later, but think about how you can use technology to be able to work a little bit more efficient and smarter in how you process it. And just remember that we've got those rules now that employees must be given a reasonable opportunity to take their leave in the holiday year. They must be encouraged to take the leave in the holiday year that they've accrued it. These are really important, so make sure that you're doing all you can to publicise, communicate your holiday rules and making sure it's being taken, because essentially holiday leave fundamentally is about health and safety, giving people time out from work. Train your line managers on managing holiday calculations and processing it all, and make sure you've got clear policies setting out the rules and entitlements, and make sure your contracts are worded appropriately, especially if you're now going to be considering moving to rolled up holiday pay and things like that. So we've got a couple of scenarios. In this one, we are looking at somebody that's working irregular hours. They're paid monthly, so that's their pay frequency. They're entitled to the statutory only, and in the month of June, they worked 103 hours. So it's about working out how much holiday they accrued in June for the hours that they worked, and you obviously need to use your 12.07 method. Remember, if you offer contractual, it'll be a different percentage. And what you can see here is you simply get the number of hours that they worked in the month and the pay period. So in June they worked 103, divided by 100 and times it by your 12.07. So that's telling you that Alex received or accrued 12.4321 hours of holiday in June. So you've got your entitlement. You then need to think about what that equates to in pay. So that's quite a straightforward applying a 12.07%. You just need to know the number of hours that they worked in that pay period. So when we think about pay, so if this same person is now paid weekly, their hourly rate is £10.42 per hour for all the shifts. But in the week of the 1st to the 7th of October, they worked 35 hours. And you need to work out rolled up holiday pay for those 35 hours that's equivalent to their entitlement prorated. What you need to do is to multiply the hours worked by the hourly rate. So you've got 35 hours worked multiplied by the £10.42. So that gives you £364.70. You then have to divide the total pay in that pay period by 100, giving you £3.65. And then this is where your 12.07% or equivalent if you offer enhanced, that's where you then use that percentage. So you multiply your £3.65 by your 12.07. So that gives him a value of £44.05 in terms of holiday pay for that, for the 35 hours that they worked. That's what they would be due to be paid. So I'm now going to show you calculating pay using the 52-week reference period method. And it probably looks worse than what actually is, but hopefully we'll take you through it. So in this scenario, if somebody's wanting to take 1 week leave next week, let's get the slides on. Let's go back there, sorry. Okay. So what you'll see is you've got a week split out, taking you right through to up to 59. And that's because to find your 52 weeks worth, you've had to go that far, because as you'll see, there are some weeks that are discounted and you don't include. So if you remember those rules that I said a few slides back, and I tell you what, if you go on to the next slide, this is probably, so what it's saying is that week 1 they earned £300, you include for the following 4 weeks, so week 2 through to week 5, they earned £350 in each of those weeks, so that's another 1,400. Your week 6 is discounted week because there's zero pay. You count week 7, so they got this £10. You then look at 15 weeks where they received £100, totaling 1,500. So there you can see on the table 15 weeks where they're getting money. So essentially, over those 52 weeks in that table, they've earned 12,040. So on average, and then to get the average weekly pay, you then have to divide it by 52 weeks. So that is saying that that individual received £231.54 in holiday pay. That's a week's pay. So that's taken into account money that they've earned. So hopefully that helps. I'm going to run another poll here. And I suppose it's a good opportunity to just find out if there's a kind of information or support that you think would be helpful, either about us creating new templates, support tools, training. Let us know.
Yeah, it's interesting. We've literally had hundreds of questions with many different scenarios. So I am thinking that there may be some interest in an actual workshop on calculating with more examples. There are so many different scenarios people have that yeah, we'll never get through them today. But there are definitely some questions around it. But it's more the patterns thing, you know, how you apply the variable patterns and the uniqueness of those situations to their scenario. So, okay, I'll close that poll now.
Thank you.
Okay.
So we have a few minutes, or actually no, it's 1 minute past 11, but are there any sort of questions we can quickly take if you're happy to, if you've got a little bit longer, Sue?
Yeah, so that some of the more general questions. So people are asking about what are the rules regarding bank holiday entitlement for part-time staff who do not work on Mondays. We've had the converse as well for those who do work on Mondays. So I guess it's using the calculation is the 5.6 weeks includes bank holidays, doesn't it? So
they're getting a proportionate amount, aren't they, in that calculation, because that 5.6, which is the same as saying 28 days, it includes your bank holidays.
And I think for staff who do or don't work on Monday, all it means, if you work on Mondays where most of the bank holidays fall, then you'll have less of your holiday entitlement to take when you want to. Whereas if you don't work Mondays, you'll still get the same entitlement if you work the same days a week as somebody who does work Mondays, same number of days a week each week, but you will have more flexibility on when you take the time off to take a week off. So and it is fair. It sounds unfair, but it is if you look at it. To take a week off, you still need to take 3 days leave whenever you work them. So and most people want to take a week off to go away or to have a decent break, and obviously it can impact on when you want an odd day off or an odd half day off, but generally when you want to take a week off, you just need to know how many hours you need to book off to take the whole week. So I think that's probably some of them. There is a question about how normal is it for companies to ask employees to take a certain percentage of their annual leave at a certain point throughout the holiday year? This is to avoid employees all taking leave at a particularly busy operational time of the year, which is also I was referring to earlier about holiday years are sometimes geared around it to avoid
Yeah.
that build up. Sometimes they, I have seen policies where you have to take the holidays accrued in the quarter, within that quarter, so
Yeah.
that it spreads it throughout the year. Some can apply different rules to different teams, because it might be that if you have office-based teams and you have a sort of factory-based teams where there's more impact perhaps on having so many people off. You can restrict how many are off at any one time, but you can equally, you can say, you know, you can send them a report regularly and say, you've got X amount of leave still to take. Please can you sure you take it, you know, as per our policy, to make sure that you don't leave it all to the end. Some people can have another question actually around, can you actually sell back holiday? So holiday in excess of the statutory minimum, you can, if you wish, say to employees, if they get, as long as they've taken their statutory minimum, so under the health and safety regulations, they have taken leave during the year, you can offer to sell, buy back, sorry, from them, or they can sell to you so many days leave, depending on your annual leave entitlements. So yeah, you can absolutely do that. Some people buy leave, some people sell leave.
Yeah. I think, you know, as long as all the rules are being applied under the regulations that we've gone through, it's down for employers as to how they develop their holiday policy, isn't it? And the rules they have in place. But as long as employees are getting their full entitlements. And the other thing to remember, like I said, you know, the point of the working time regs, it's a health and safety piece of legislation. The reason why people are given holidays because they need that rest from work. So it's about making sure, you know, people aren't taking it all in one go, for example. That could be a rule. Only in exceptional circumstances do you allow more than 2 weeks, perhaps. But yeah, okay, that's really good question.
Yeah, so there's a lot around the actual management of leave, which is what's we were talking about before today, that we might look at running something about managing holidays, not just sickness absence, but actually holidays, because there's quite a lot to it. So I think that's all the sort of general questions, and we will come back to you. The many questions about different scenarios. We will try and group them and come back with an answer that hopefully helps you all afterwards. But some of them will take some thinking and working through. That it's just not practical today. Okay.
But thank you, and thank you for all those questions, everybody. I did mention actually we do have a calculator on our main website to use either if you're managing regular part-time hours or irregular part-time hours. So that's something that you may find of help. But yeah, and there's also some guides as well on our hub, so please do check out the QR code there. We also offer a free audit for you to take part in, so it enables you to assess your own organisation against statutory requirements, and it gives you a report at the end to understand you know, to what extent you're complying, and if there are any gaps, then where those gaps are. So do check that risk audit out, and as you'll know, we're going to be developing it even further as we know more about the new employment right reform bills. So but yeah, there's the risk audit there that you can do now. Please do keep in touch with us. You can sign up to our newsletter, you can follow us on LinkedIn, you can get in touch. There's my email there. We've got contact number, and obviously you can find us online as well. We offer a HR knowledge base, which is an online HR resource. It essentially provides template HR documents and policies, articles that there must be 500-600 articles that cover the entire employee life cycle, as well as guides, checklists, letters, forms, etc., and provides a lot of guidance on a wide range of topics. And we are going to be running several other webinars throughout the year. Our next topic for April will be about redundancy in 2025 and talking about how it can be prevented, process needed, and just essentially key steps in making that smooth transition. We're going to be focusing on statutory sick pay because we've got some significant reforms coming in that area. So that's going to be the topic of May's webinar. And in June, we're going to be talking about changes to 0-hour contracts. So that's going to be a big area of reform as well under the Employment Rights Bill. We're also going to be covering in July about family-friendly leave and preparing for more flexible working requests, because we are seeing changes in that area of the law that's expected to come in. And in August, we're going to be focusing on probation periods, because that's going to be something that we'll see next year when they introduce a statutory, when the government introduces a statutory probation period. And then in September, we're looking at the primary areas of discrimination. And in October, we're going to see cover how we can protect the business from tribunal claims. So do sign up to our webinars. There's a QR code there. And there we go. That's what's coming in 2025. As you'll see here, there's a free 30-minute consultation with one of our experienced HR advisors. It might be you've got some performance issues, you're trying to navigate absence, a cultural change that you want to focus on. Do check us out. There's a QR code there. And there we go. So thank you everybody for your time today. Apologies for overrunning slightly. I hope you found it useful. It is a complex area, so do get in touch if there's anything that we can help you with. We're always here to help and support. But thank you. Have a good rest of the week, and thank you, Sue, for your help as well in the session. Thank you, everybody.
Thank you.